Well, we resume this bulletin tonight starting with the story that the Court of Appeal on Friday upheld the federal government's application for stay of execution of the October 13 judgment, which set Nnamdi Kanu free. Justice Haruna Tsesamani also ordered that the result of the ruling be forwarded to the Supreme Court within 7 days for expeditious hearing. This means Kanu is expected to remain in the custody of the Department of State Services pending when the Supreme Court hears the case. Kanu has been in detention since he was brought back from Kenya on June 19, 2021. The Court of Appeal in Abuja has overturned the judgment which sacked David Umahi as governor of Ebonyi State. The appellate court, in a unanimous decision by a three-man panel led by Justice Haruna Tsesamani, held that there is no constitutional provision for the removal of a serving governor or deputy governor that dumped the political party that sponsored them to power. The judge, in his lead judgment, said the sole recourse available to a political party aggrieved by the defection of a governor or deputy governor is to explore the constitutional provision of impeachment. On March 8, Inyang Ekwo, judge of a federal high court in Abuja, held that the 393,042 votes polled by Umahi in the March 2019 governorship election belong to the PDP and cannot be legally transferred to the APC. Consequently, Ekwo ordered the PDP to present another candidate, or in the alternative, the Independent National Electoral Commission, INEC, should conduct a fresh poll within 90 days. Well, to speak more on these developments, legal expert Ufeli joins me now. Thank you very much for joining us. Now, we had two remarkable judgments from the appeal court today, but let's begin with the decision of the Court of Appeal to uphold the federal government's application for stay of execution of the October 13 judgment, which set Nnamdi Kanu free. What do you make of this?
Well, you know that the Court of Appeal recently quashed the 15-count charges. That is the 7-count charge that was remaining after the Court of First Instance, the Federal High Court in Abuja, had first quashed the 8-count charges. Now, ordinarily, it was expected that having quashed the 15-count charges, Kanu was supposed to be discharged, okay? But the federal government now filed what you call a motion to stay execution of that judgment. And then today, the motion to stay execution of that judgment was granted, pending the determination of the substantive suits which have been filed at the Supreme Court. And the Court of Appeal have also given the federal government 7 days within which to transmit record to the Court of Appeal so that the appeal of the federal government can be heard by the Supreme Court. The implication of this is that Nnamdi Kanu will still remain in the custody of the federal government until the determination of the substantive suit by the Supreme Court. But the only part that is not that has not gone down well to some of us who argue legally is that as at the point Nnamdi Kanu, as at the point the Supreme Court discharged him of the 15-count charges, he ought to have been released at that time. It was wrong for the federal government to still keep him in detention pending what they intend to do next. Like the Attorney General of the Federation said, that he will remain in custody. The federal government is thinking on what to do. That was actually wrong. But thankfully, they have been able to put forth their motion to stay execution of that judgment. And same has been granted today. So what it automatically means is that Nnamdi Kanu will still be in the custody of the federal government pending the determination suit by the Supreme Court to determine his fate.
Now the course is, of course, clear for the Ebonyi State Governor and his deputy, but can we say this judgment has made clear the argument on defection and transfer of votes?
Yeah, you know that of the governor. When a governor defects from one political party to another, it is not provided for in the Constitution as an infraction. Unlike a lawmaker, if a lawmaker defects from one political party to the other, the law says they can do that, but they can only do that under certain circumstances where they can show that there is animosity, there is crisis in their current party, such that the party is unable to function. In such case, they can defect, even though many of them have abused that power. But as to the executive, there is no point in the law whatsoever, even though it is argued the Supreme Court have plethora of judgment that says that it is the party that contests election and not the candidate. Now, David Umahi sometimes ago defected from the People's Democratic Party to APC. Now, when he defected to that party, so they brought an action against him to say that him and his deputy, that having defected from the PDP, that seat should be vacant. The Court of First Instance gave judgment that he should cease to be governor. Him and his deputy should cease to be governor, and that the PDP can field in any other candidate. And then what happened thereafter is that they went on appeal. That is, Umahi went on appeal, and the appeal court just gave the judgment today, stating that there is nowhere in the Constitution where the law made express or implied provision to punish a governor, a member of the executive, who defect from one political party to the other. Perhaps it negates the argument that it is political parties actually that contest elections and not the person, because ordinarily, if the fact is well established that it is political party that contests election and not the candidate, it stands to reason that if a candidate defects, because if a political party has won an election, okay, that vote that the political party had cannot be transferable to another political party. So by the time a person defects, ordinarily his defection should mean his seat should be declared vacant. But the only omission, the lacuna that exists there is that there's no express provision in the Constitution, okay, that says when you defect, you lose your seat. And the principle of law is that once there is a law or that case law or whatsoever that is contrary to the provision of the Constitution is supreme, and this provision shall have a binding force on all persons and authorities.
Well, but I'm sorry to interrupt you, Evans, but we have to leave it there for now. But legal expert Evans Ufeli, thank you very much for your time and your contribution.